Good.
Can everybody hear me okay?
It's better.
All right. Well, good morning, everyone, and welcome to Township Tuesday, November 5th, 2024, and happy Election Day. Hope everybody is doing okay. So, I thought today we'd talk about something that was a little bit topical, at least in the sense that we'll all be doing it fairly soon, and that is town role as board of canvas. So we're going to talk a little bit about deadlines. We're going to talk about membership in that board, duties, open meeting law implications, and my favorite subject: what do you do if there's a tie? So, uh, please do let me know if I start to mumble or if you can't hear me. But let's move right along here. So the big stuff, or the big one to know, is the deadline here, and there are two provided by the statute. So it's 205.185, and it says 3 to 10 days after a November election and 2 days after a March election. So folks who have your elections in March, this is one to keep a good hold of, because it is shorter than the open meeting law period. But we'll get into that one for November, folks. You have quite a bit more leeway there. One of the odder bits about this law that I sort of ran into, and one of the things that sort of prompted this presentation actually is this question: who ends up serving as a member of this board of canvas? And it has to be the supervisors. Oddly enough, um, there is no provision made for removing folks who are currently on the ballot. So it's Minnesota Statute 205.185, subdivision 3 says the governing body of a town conducting the general election shall act as the canvassing board. So the question came up: do we disqualify folks who are on the ballot? There's no provision in law for that. Called the Secretary of State's office. They seem to think the same. Seem to think it was a little strange, but that is in fact what the law says. So, little entertaining one there. Now, one thing to be aware of, particularly for folks on the March schedule, is that this does count as an open meeting law, which means that you need to have it needs to be open to the public and proper notice needs to be given. The easy way to do this is to place it on the regular schedule of your meeting. It's a regular meeting, great, no problem, you're good. If that got forgotten, then you're going to have to call a special meeting. So that means posting notice of the time, place, and purpose at least 5 days, and that's an asterisk there, prior. Now, if you look, the reason for the asterisk is this: if you look at the statute, it's going to say 3 days, but there's another statute in a different chapter that says you're not supposed to count the first day, and then there's another statute in a different chapter than that says you're supposed to add a day if it's less than 7. So the legislature really liked playing scavenger hunt with this one. So we recommend 5. You do not have to publish, but you do have to mail special notice to anybody who has requested it in writing. Now, that's not particularly common, but it does happen. Okay. This is a new body. It's technically a new office, legally speaking, so there is a separate oath for it. We've got an example oath here for folks who are interested. It is essentially the same as our normal oath of office. We're just, member of the board of canvas is replaced there. So there's no particular, you don't feel like you need to take a screenshot of this one. Just, it's the same oath of office, but with member of the board of canvas in it. Now, taking the steps here. So pretty straightforward, coming from Minnesota Statute 205.185 plus guidance from the Minnesota Secretary of State's office, but the clerk prepares a report. The board takes an oath of office. Then the board publicly canvasses the election returns by reviewing the abstract and write-in reports. So you can ask to examine summary statements, and then when you are satisfied that the abstract reports are correct, you sign them and they become the official results. Well, okay, but what happens if you're not satisfied? So there are procedures in law to deal with this. slow down is our recommendation. Seek legal assistance and make sure that you're doing this stuff properly. But there are some examples here. So the Secretary of State's office and the Township Association have traditionally pointed to 204C.38. You can see a little excerpt from it there on your screen, and also 204C.39. Now, 38 is one that sort of relies on the candidates all agreeing, but of course, that's not always the way things go. So there's also 204C.39. Now, this one is more limited than folks think. It is, so the Minnesota Attorney General has opined that this one is available if you are talking about errors that are so obvious that they can be determined before, without actually inspecting ballots. So the example that they give is if you're in a situation where the total votes cast for one office exceed the total number of voters in the precinct, there's an obvious problem there. So this is kind of what that one is for. But that's not all of the processes that are there in law. There's also the contest process in Chapter 209. Now, that one's really for candidates. And there's the general errors and omissions process in 204B.44. Now, one thing that I did want to highlight for folks is there is a bit of an ambiguity in the statute here. Now, traditionally, and Matt and the Secretary of State's office have taken the view that the provisions that I was just talking about, 204C.38 and .39, have correction procedures that are available to township boards sitting as Board of Canvass. Now, strictly speaking, those statutes talk about county boards. So there is this weird little argument out there that maybe it's supposed to go to the county, maybe it's supposed to go to us. This is one of the reasons that it's important to slow down if you find yourself in this situation, which you probably won't, but just in case, it's my job to make sure that you guys kind of understand the lay of the land here, legally speaking, as much as you can. So write-ins, fairly simple. Handled in just the same way that we handle everybody else, contacted with the results, issue their certificate after the contest period is run, and they must take that oath within 10 days or a vacancy occurs automatically. Now, this one is probably one of my favorite bits of legal trivia here. What happens if there's a tie? What do we do? We're the Board of Canvass, right? We're the ones who are supposed to determine the winner. It is determined, quote, by lot. Seriously, that's the law. So examples of this stuff, we've got in the year 2000, they broke a tie in a city by cutting a deck of cards. Coin flip in Maplewood in 2003, coin flip for the mayoralty of Goodridge. 2014 was drawing colored pieces out of a bag, and that one was for Cook County Commissioner. Now, one thing you should know is there's no definition of lots here provided in statute. It is just so we think that the way to think about this is this. So it has to be fair. You're going to want to be conscious about cheating. You're going to want to be conscious about probability of win. It's got to be equal for everybody who is a participant in the tie. But also, you're going to want something that is unambiguous and public. So I recommend pretty strongly that you start thinking about the physical details of the space. You don't want to get into a situation, if you're in this situation, you don't want to get into a situation where you're rolling a die or flipping a coin or something and it falls off the table. And now you got to scrabble around on your hands and knees and looking for it. And now you have to have a fight about, all right, did somebody bump it? Is that really the result? So it's a good idea to pick something that everybody in the public who happens to be attending can see, and something that isn't subject to that kind of fumbling kind of stuff. Unambiguous, equal chance to win, fair, and publicly verifiable. Those are kind of the lodestones, I think, of how you make the decision about what specific method you're going to end up using. But just so you know, there really isn't much law about this. Any method of chance is probably acceptable, so long as it meets that equality criteria. Now, okay. Once all of that is done and we've canvassed the results, we've signed off on them, or we've started our procedures, next step is for the clerk to certify the results to the county auditor. Now, the clerk is the final custodian of those ballots, and they are supposed to be under lock and key. Contest period begins. Candidates next file their campaign statement with the clerk. There are certain records retention requirements and publication requirements for towns that have more than 400 registered voters. You're supposed to publish these things on your website, and you're supposed to post the reports and keep them available for 4 years. But then once you get done with this contest period, clerk is supposed to issue the certificate of election, and then they've got their 10 days to take the oath of office. Otherwise, you get that automatic vacancy. Now, we do have a nice little updated EL 7000. That one should be going up either today or tomorrow for folks who are interested. It's got a sample agenda. It's got a sample precinct summary statement. And then we've got sample certifications in our election law section for our information library. So, okay, folks, let's see, we got a couple of chats. If supervisors are doing the board of canvass, they have to do the oath of office too. Yes, it's the supervisors who are on the board of canvass, and those folks are the ones who take their oath of office as a member of the board of canvass. So it's separate oath, kind of the same thing as we've already done, but strictly speaking, you're supposed to do it. So just so you know, that one's out there. You can use our sample oath of office. The office there that you would be swearing to is member of the board of canvass of the township of whatever township you happen to be. But yes, you're supposed to start that with the swearing. 398 registered voters at 7 a.m. and one seemed, oh no. So if you have a website, do you have a website? No, then you don't. This thing is phrased in terms that, I mean, like publishing requirements online are coming like a freight train. This is something to start getting prepared for now. But at least as the law currently stands, it is only if you have a website, you have to publish these things on the website. If you do not have a website, you do not have to have a website. We have been, so Steve before me, and I've been relatively active with the legislature trying to make sure that there's not a requirement out there for towns to actually operate websites. And so a lot of these requirements are phrased in terms of if you have one, then you have to do this, that, and the other. But if you don't have one, for the most part, you don't have to do all of this stuff. What if township clerk is not overseeing the election as head election judge? It's a former clerk. So a lot of these duties are phrased in terms of the town clerk or the sort of filing officer or responsible officer. So the duties that we just talked about, the town clerk being responsible for the ballot, that one goes to the town clerk regardless of who the head election judge is. And here, let me go ahead and show that statute to you, because why the heck not? Just a moment here. This one is important enough that it is worth looking at. Alrighty, just a second. There we go. All right. So here's what we're looking at. The clerk shall be the final custodian of the ballots and returns of the election, and the clerk shall certify the election results to the county auditor. So those duties are not, they don't go to the head election judge, they go to the clerk. That is correct. Okay, yeah, I'd be happy to sort of walk through and put up all of those different requirements. They have very much played legal scavenger hunt with that one. That is, the requirements of what needs to go up on the website. So there's the financial statements, That's one of them. Let's see, there's a requirement that if you have one, you should be transitioning to a .gov, although that one's, strictly speaking, that's limited to jurisdictions that administer an absentee voting system. So it's phrased in kind of a weird way. Let's see, I know I'm forgetting one or two here. Um, yes, that it's a great idea, Reno. I will make a point of creating a resource on that one. I think it's definitely time. We're seeing some fairly regular pushes at the legislature to kind of include this kind of stuff on websites, and they are not doing a good job of putting it all in one place. So if you're just paging through the statute book, you're gonna miss most of it. Um, Board canvas oath. Uh, Well, so it is just our oath of office with the oath filled in with the appropriate office. So if you go on our information library, you're looking for the oath of office. It'll be it's substantially the same oath, just that one happens to be filled in. Now that language is just member of the board of canvas. So that's what I would do is go on our information library and get that document. Okay. Any other questions here? Okay, folks. Well, what's the difference between swear and affirm? So some folks have religious objections to swearing, and the law is designed to accommodate that. And well, it doesn't even have to be religious in character. You can just be a person who is not comfortable swearing oaths. Usually, the objection there is religious, but point is, as part of the free exercise clause and all of that, you're supposed to be able to do this without violating that particular bit of conscience. So, legally speaking, there's no difference. All it is you're characterizing it as an affirmation. The point is that you are potentially subject to penalties. All it means is you understand that this is a serious matter, and consequences will potentially accrue to you if you're dishonest when you either swear or affirm. That's the important thing. So do we swear in the new officers at our regular meetings? That's soon enough to not have vacancies. So it depends on whether you are a March or a November election. So November, for whatever reason, they decided to do different timelines for this. For November, it's within 10 days. And strictly speaking, it operates as a vacancy if you don't fill out that paperwork within 10 days. Yeah, that's harsh. I, I mean, look, there isn't going to be a dragnet for this to make sure that everybody's filling out their paperwork correctly. But at the end of the day, it's my job to make sure that you guys don't take legal risks by accident, and that is, potentially a legal risk. For March elections, as memory serves, it is before exercising powers. So regular meeting is usually soon enough. Actually, you know what? Let me lay my hands on that one specifically. I don't want this thing to go up and for me to get that wrong. Don't practice law from memory here. So just a moment. I believe we are talking about Minnesota Statute 367.03 and da, 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 da. So this one. I'm law here. All right. Let me give me just a minute here. All right. candidate elected in March assumes the office upon the proper filing of the oath with the town clerk. Let's see. Yeah, so I believe that that one is correct. All right. So yeah, that like 36703 sub 4 is the authority there. So yep, that is before assuming office is the standard. So okay, any other questions? All right, folks. Well, happy election day. Hope things go well and smoothly for you. And thank you for your time and for your attention. And have a good morning, everyone.